Gareth Sloman, step away from the fee orders.
Fine, just don't disturb the active matters.
The kickbacks were calculated from attorney fees you assigned.
Then seal the room, preserve the binders, and stop acting like this is complicated.
This operation had been in the works for nearly a year. Judge Gareth Sloan walked right into it, and the FBI recording running in that room captured every word he said.
It's complicated.
$520,000 flowed through the courier and consulting account.
You'll need the appointment calendars from that shelf and the fee ledgers from the cart.
He would not get the chance to explain. Within 72 hours, federal agents would seize his phone, his laptop, and a leather-bound docket calendar that cataloged 14 years of judicial appointments. Approximately $520,000 had moved through a courier, a relative's consulting account, and a series of cash drops arranged in restaurant parking lots across 3 Oklahoma counties. The protected persons whose estates funded that flow never knew their money had been redirected. They were, by legal definition, incapable of knowing. Pay attention to the dollar amount in this case. Now think about who paid it. Not taxpayers, not the state. The money came directly out of the estates of elderly and incapacitated people whose bank accounts a court was supposed to be protecting. If that lands the way it should, drop a comment telling me what you think a fair sentence looks like. Subscribe if you're new here, because these are the cases that don't make national news, and this channel exists to make sure they don't disappear. Gareth Prescott Sloan was born on the 14th of August, 1963, in Cheyenne, Oklahoma. His father, Emmett Sloan, ran a cattle operation on 1,100 acres in Roger Mills County. His mother, Delphine Sloan, worked as an official court reporter for the 4th Judicial District, transcribing hearings for 2 rural counties and driving 80 miles a day to do it. She kept her stenotype machine on the kitchen table because the family only had one desk, and Gareth grew up watching her fingers move across those keys while she reviewed the day's transcripts under a yellow ceiling light. He was the middle of 3 children. His older sister taught school. His younger brother stayed on the ranch. Gareth was the one who went to the law. His high school civics teacher would later tell reporters that Gareth was the only student she had ever seen ask, unprompted, to visit the county courthouse on a field trip that had been optional. He was 15 when he first sat in the gallery of a real courtroom in Cheyenne and watched a district judge decide a will contest between 2 brothers over their late father's mineral rights. He told his mother afterward that he had understood every word. He graduated from Cheyenne High in 1981 and enrolled at Oklahoma State University in Stillwater, majoring in political science with a minor in agricultural economics. He worked 30 hours a week at a feed store on Range Road to cover the portion of tuition his parents could not. His academic transcripts, later reviewed during his federal background investigation for judicial appointment, showed a grade point average of 3.71, with faculty comments describing him as reliable, methodical, and, quote, unusually attentive to procedural detail for an undergraduate. He entered the University of Tulsa College of Law in the fall of 1985. He was one of 37 students in his section, and he graduated in the top 15% of his class in 1988. His law review note, still archived in the Tulsa Law Journal, examined the appointment of guardians ad litem in Oklahoma probate proceedings and the statutory framework governing their compensation. The note was cited twice by later scholars. The subject matter would decades later become the exact statutory territory he would exploit. He took his oath as a member of the Oklahoma Bar in September of 1988. His first job was as an assistant district attorney in the Oklahoma County District Attorney's Office, prosecuting misdemeanors and low-level felonies out of a courtroom on the 4th floor of the county courthouse on Robert S. Kerr Avenue. He earned $29,200 in his first year. He stayed for 4 years, tried 31 jury trials, and left with a reputation described in his personnel file as, quote, exceptionally prepared and steady under pressure. In 1992, he moved into private practice with a small probate and estates firm in Enid, Oklahoma, called Hurley, Redmond, and Ash. His practice was almost entirely guardianships, conservatorships, and estate administrations. He drafted wills for retired oil workers and their widows. He served as court-appointed conservator on 23 matters over 11 years. He learned, from the inside, exactly how appointment fees flowed, exactly who decided who received them, and exactly how quietly the process ran when no one was paying attention. He married Marguerite Hallowell in 1994. She was a hospice social worker who had done her clinical training in a nursing home in Guthrie. They bought a 2-story brick colonial on Elm Vista Drive in Cedar Bluff, a subdivision on the north side of the county seat of Marlin Springs. They had 2 children, a daughter and a son, both born in the late 1990s. Marguerite continued her hospice work part-time. Gareth ran for the bench in 2010 after 15 years of building his private practice into a small but respected estate operation. He won the general election with 58% of the vote and took his judicial oath on the 2nd of January, 2011. His judicial assignment placed him on the general civil docket with a specialized concentration on guardianship, conservatorship, and probate matters. His peers on the Penwick County bench described him, in the years that followed, as measured, courteous, and unusually knowledgeable about the substantive law of protected person estates. His judicial performance evaluations from the Oklahoma Judicial Council, conducted every 4 years, consistently rated him at or above the standard set for retention. In his 2019 evaluation, one anonymous attorney respondent wrote that Judge Sloan, quote, understands guardianship law better than anyone else on this bench and treats appointed counsel with respect. That respect, investigators would eventually establish, was not evenly distributed. It was allocated by a specific criterion that had nothing to do with legal ability, professional standing, or the interests of the protected persons whose estates the appointed attorneys were supposed to safeguard. It was allocated by who paid. To understand what Gareth Sloan did, you have to understand the system he was elected to administer. In Oklahoma, as in most states, the guardianship and conservatorship court exists to solve a specific legal problem. When a person becomes incapable of managing their own affairs, whether through advanced age, dementia, traumatic brain injury, developmental disability, or long-term mental illness, the court steps in to appoint someone to make decisions on their behalf. That appointed person is called a guardian if they manage the person's care, or a conservator if they manage the person's finances. In many cases, one person or entity serves as both. Because the protected person cannot advocate for themselves in court, the judge also appoints an attorney to represent their legal interests, and often a guardian ad litem, a separate independent attorney whose job is to investigate the situation and report to the court on what arrangement would serve the protected person's welfare. These appointments are not volunteer positions. Every appointed attorney, guardian, conservator, and guardian ad litem earns fees for their work. Those fees are paid from the estate of the protected person. That is the structural pressure point. The estate pays. The protected person cannot supervise the payment. The court decides who receives the appointment and therefore who receives the fees. In Penwick County, over the 14 years of Sloan's tenure, the guardianship and conservatorship docket generated an estimated $14 million in fee payments to appointed attorneys and fiduciaries. Every dollar of it came from estates that a court had determined the owner could no longer manage. The Oklahoma statutes provide standards for how appointments should be made. Judges are directed to select from qualified attorneys, to distribute appointments equitably, and to consider factors like experience, availability, and the specific needs of the protected person. But the statutes do not require a lottery. They do not require a public bid process. They do not require published criteria. The final appointment decision rests, and has always rested, in the discretion of the individual trial judge. That discretion is what makes the system work when it works. A judge with experience in guardianship matters knows which attorneys handle contested capacity cases with skill, which conservators can manage a complex real estate portfolio, which guardians ad litem will actually visit the protected person in the nursing home instead of filing a 2-page report from behind a desk. Discretion, exercised in good faith, produces better outcomes for people who cannot produce them for themselves. But discretion, unmonitored, is also a vulnerability. There is no public tracking of appointment frequency in most Oklahoma counties. There is no automatic audit trigger when a single judge appoints the same 3 or 4 attorneys at rates that deviate from the available pool. Protected persons have no organized advocate. Their families, if they exist, usually accept whoever the court appoints. The bar associations do not typically challenge judicial appointment patterns because the attorneys who might raise concerns are the same attorneys whose livelihoods depend on future appointments. Gareth Sloyne understood this system with the precision of someone who had spent a decade practicing inside it before he ever put on a robe. He knew where the reporting requirements ended. He knew which decisions were appealable and which were not. He knew that a guardian ad litem's fee application, once approved by the appointing judge, was almost never questioned by anyone. He knew that the estate paying the fees had no voice, no representative other than the very attorneys the judge himself had selected, and no mechanism for detecting whether the appointments were being made on merit or on some other basis entirely. He knew all of it. And starting sometime in 2021, he decided to use it. The arrangement began, according to what the federal investigation would later reconstruct, in the spring of 2021, during a period when Sloyne was serving his 11th year on the bench and had built the kind of established relationships with local counsel that made a quiet approach possible. The 4 attorneys who would become his paying counterparts were not strangers. They had appeared before him routinely for years. They were experienced in guardianship work. They understood the fee structures and the flow of estate money as thoroughly as he did. The first attorney to enter the arrangement was Delbert Rausch, a solo practitioner from Marlin Springs who had handled probate work in Penwick County for 22 years. According to the federal indictment, the initial conversation took place at a bar association reception at a country club on the outskirts of Marlin Springs on the evening of the 8th of April, 2021. What was said between them at that reception was never captured on any recording, but the arrangement that followed was documented exhaustively in the money. The structure was simple in its outline. Sloyne would preferentially steer guardianship and conservatorship appointments to Rausch. Rausch would earn fees from the protected person's estates. A portion of those fees, initially set at 15% and later increased to 20%, would flow back to Sloyne. The flow would not be traceable through any direct bank transaction between the two men. Instead, Rausch would pay a cash intermediary, a courier, who was later identified as a distant cousin of Sloyne's wife, and the courier would deliver the cash to Sloyne at prearranged locations. A parallel structure routed some payments through consulting invoices submitted to a business account held by a Sloyne relative in a neighboring county. Within 4 months of the initial arrangement with Rausch, 3 additional attorneys had entered the same structure. Kenton Whibley, a former ADA turned probate specialist. Marisol Trant, who had spent 15 years handling elder law cases. Eugene Pomerantz, a Tulsa-based attorney who had begun taking Penwick County appointments in 2020 and rapidly increased his volume in 2021. Each of the 4 operated independently of the others. Each paid separately. Each received their appointments individually without knowing, or at least without acknowledging, that they were part of a coordinated arrangement. The appointments themselves were unremarkable on their face. Sloyne would sign an order appointing Rausch as attorney for a protected person, or Trant as guardian ad litem, or Whibley as conservator. The orders looked identical to appointments any judge would sign. The signatures, the docket numbers, the boilerplate language, all of it was standard. What was not standard was the frequency. Between April of 2021 and the spring of 2024, Sloyne appointed one of the 4 paying attorneys in approximately 71% of guardianship and conservatorship matters that came before him. In the 4 years prior to the arrangement, that same group of 4 attorneys had received 23% of his appointments. The fee flow generated real numbers. Rausch billed the estates of 38 protected persons over the 3-year period, generating gross fees of approximately $640,000. Whibley billed 29 estates for approximately $480,000. Trant, 21 estates for $310,000. Pomerantz, 34 estates for $720,000. The combined gross was approximately $2.15 million in appointed attorney fees paid from protected person estates over 3 years, of which approximately $520,000 flowed back to Sloan. The money moved. Cash envelopes exchanged at a diner on Highway 34, at a fishing lodge outside Grand Lake, at a parking lot behind a hardware store in the small town of Fenner. Consulting invoices, drafted by Sloan's wife's cousin's small accounting practice, described services that were never rendered. Bank deposits into the relative's business account, followed by transfers to a personal account controlled by Sloan through a joint signatory arrangement. The federal forensic accountants would eventually reconstruct the flow across 11 separate accounts, and the protected persons paid. Norma Jean Vickery, 84 years old, advanced Alzheimer's disease, no living children. Her estate was valued at $470,000 when the guardianship was opened in 2022. Rausch was appointed as her attorney. Over the 18 months between the guardianship's opening and Mrs. Vickery's death, Rausch billed her estate for $41,000 in fees. A portion of that flowed to Sloan. Mrs. Vickery, who had raised 3 foster children in the 1970s and taught Sunday school at a Methodist church in Marlin Springs for 30 years, never knew. Elston Redgrave, 91, a World War II veteran and retired oil field welder. Traumatic brain injury following a fall in his home. Estate value of $280,000. Whibley was appointed as his conservator. Over the 2 years of the conservatorship, Whibley billed Mr. Redgrave's estate for $57,000. A portion of that flowed to Sloan. Mr. Redgrave, who had fought at Okinawa and had voted in every general election of his adult life, never knew. Mercy Halton, 79, early onset dementia. Genevieve Ortlieb, 86, stroke recovery. Wilfred Cranston, 93, blind and diabetic. Case after case, estate after estate. The pattern was consistent. The paying attorneys received the appointment. The estates paid the fees. Sloan received his cut. And the protected person, in every instance, was structurally incapable of noticing. The man who ended the arrangement was named Miles Enderby. He was 53 years old, a guardian ad litem in private practice in Marlin Springs, and he had appeared before Judge Sloan for 11 years. Between 2013 and 2020, Enderby had received approximately 18 guardianship and conservatorship appointments per year in Penwick County, a workload that had made up roughly 40% of his solo practice's revenue. In 2021, that number dropped to 9. In 2022, it dropped to 4. In 2023, it dropped to 1. Enderby was not stupid. He was, in fact, an unusually attentive lawyer. He noticed the drop in his second year and initially attributed it to a general slowdown. But by early 2023, watching the same 4 names appear on appointment orders in matter after matter, he began to keep a private record. He tracked every guardianship and conservatorship opening in the county. He noted which attorney was appointed to each role. He compared his own appointment volume to the volume of Rausch, Whibley, Trant, and Pomerantz. The pattern was undeniable. He was not the only lawyer who had noticed. 2 other guardian ad litem practitioners in the county had complained, informally, about the appointment pattern. But complaints of this kind rarely go anywhere. Judges have wide discretion in appointments. The Bar Association will not open a formal investigation on the strength of a subjective sense that a colleague is receiving preferential treatment. Enderby knew this. He also knew that in June of 2022, at a Bar Association luncheon, Delbert Rausch had made what Enderby later described in his federal grand jury testimony as, quote, an oblique suggestion about how appointment volume in the county worked and what conversations a lawyer might want to have to protect his caseload. Enderby had not followed up on the suggestion. He had walked away from the conversation. And within 6 months, his appointment volume had begun its steep decline. By the summer of 2024, Enderby had assembled a 38-page memorandum. It documented his own appointment history over 11 years, cross-referenced against the appointment histories of the 4 attorneys whose names he had come to recognize. It included copies of every appointment order he had been able to obtain from public court records. It included his recollection of the June 2022 conversation with Rausch, reconstructed in as much detail as he could reliably remember. It included his statistical analysis of the appointment concentration. On the 17th of July, 2024, Enderby drove to Oklahoma City and delivered the memorandum in person to the office of the Oklahoma Judicial Council's investigation panel. He asked for a receipt. He received one. He drove back to Marlin Springs and did not tell anyone he had made the trip. Not his wife, not his law partner, no one. The Judicial Council's investigation panel reviewed the memorandum for 6 weeks. The panel's staff performed an initial statistical review of Sloan's appointment records that broadly corroborated Enderby's analysis. On the 2nd of September, 2024, the panel referred the matter to the Federal Bureau of Investigation's Oklahoma City field office, which had a standing public integrity unit. The FBI opened a formal investigation on the 11th of September, 2024. Special Agent Nadine Kohler, a 15-year veteran of the Public Corruption Squad, was assigned as case agent. She read Enderby's memorandum in a conference room on the 3rd floor of the Oklahoma City field office on the same afternoon the file was opened. She spent the next 3 months quietly assembling the evidentiary architecture that would end Gareth Sloan's judicial career. We are about to get into the investigation. Before we do, if you have made it this far, subscribe. This channel covers cases that mainstream media does not touch, and cases like this one, where the victims are elderly people who cannot speak for themselves, are exactly the stories that get buried when no one is paying attention. Hit subscribe. The recording that ended this judge's career is coming up next. Agent Kohler's approach was patient. Judicial corruption investigations fail more often than they succeed, and they fail because they get exposed too early. A federal grand jury subpoena served on the wrong bank triggers a phone call. A witness interview conducted with the wrong lawyer in the room produces a warning to the subject. Kohler's team built the case on paper for the first 11 weeks without conducting a single overt interview. The first phase was the statistical analysis. Working with a forensic analyst from the Bureau's Public Corruption Unit in Washington, Kohler's team obtained all guardianship and conservatorship appointment orders signed by Judge Sloan between January of 2015 and August of 2024. The dataset covered 9.5 years and included 742 appointments. The analysis compared the actual distribution of appointments to the 4 paying attorneys against the expected distribution based on the total pool of qualified attorneys practicing in the jurisdiction who accepted such appointments. The result was unambiguous. In the 6 years before the arrangement, Rausch, Whibley, Trant, and Pomerantz had collectively received 23% of Sloan's appointments. In the 3.5 years after April of 2021, they collectively received 71%. The probability that this shift occurred by chance, given the size of the qualified attorney pool in Penwick County, was calculated by the FBI analyst at less than 1 in 100,000. Statistical anomaly, by itself, does not prove bribery. Statistical anomaly proves that something happened. To prove what happened, Kohler needed the words. She needed Sloan, in his own voice, on the record, describing the arrangement. The cooperating attorney was Prescott Vane. He was a Tulsa-based probate lawyer who had never taken an appointment in Penwick County, but who was known professionally to 2 of the 4 paying attorneys. Vane was approached by the FBI in early January of 2025. His cooperation was not coerced. He agreed to participate because, as he later stated to federal prosecutors, he had spent his career watching guardianship courts serve the interests of everyone except the protected persons, and he was willing to be part of the case that changed that. The controlled scenario was constructed carefully. A fictional pending matter was created, a protected person, entirely fictional, with an estate of a size that would generate meaningful fees. The court file for this fictional matter was, of course, never actually filed. The scenario existed only as a hypothetical that Vane would present to Sloan through the established channel. That channel, based on the intelligence developed from cooperating financial witnesses, was the Courier. On the 14th of February, 2025, Vane made contact with the Courier and indicated he was interested in accessing the appointment stream. The Courier, over a period of 3 weeks, arranged an introduction. On the 8th of March, 2025, Vane met with Sloan at a fishing lodge on Lake Eufaula. The meeting had been arranged through the courier as a purported social introduction. Vane was wearing a recording device authorized by a federal magistrate under Title 18 of the United States Code, Section 2511, subsection 2, paragraph C, which permits one-party consent recording in federal investigations. The recording ran for 47 minutes. In it, Sloan discussed, in detail, the mechanics of the arrangement. He described the percentage structure, initially quoting 15% and negotiating to 18%. He described the courier arrangement. He described the consulting invoice structure available for larger payments. He referenced, without naming them, the existing 4 attorneys who operated under the same arrangement. And at the end of the meeting, he agreed to appoint Vane in the fictional matter in exchange for an initial cash payment of $12,000 to be delivered through the courier within 30 days. On the 2nd of April, 2025, the courier accepted delivery of $12,000 in marked federal currency from a second cooperating source. The courier delivered the cash to Sloan at a rest stop on Interstate 40, 11 miles east of Marlin Springs, on the afternoon of the 4th of April. The delivery was surveilled by an FBI observation team. The cash was recovered from Sloan's chamber's safe during the execution of a federal search warrant on the 9th of April, 2025. The search warrants were executed simultaneously at Sloan's chambers, his residence on Elm Vista Drive, and the courier's residence in a rural area outside Fenner. Agents recovered the marked currency. They recovered a leather-bound docket calendar containing handwritten notations that federal analysts would eventually decode as records of specific appointment-to-payment linkages. They recovered a laptop with encrypted communications with the consulting invoice account. They recovered, from a locked drawer in the master bedroom closet, an envelope containing $41,000 in cash, organized in bank-strap denominations. The arrest was executed on the morning of the 9th of April, 2025, at 7:43 a.m. in the driveway of the residence on Elm Vista Drive. Sloan was in the process of loading a leather briefcase into the trunk of a 2022 Lexus sedan when the arrest team approached. He was wearing a charcoal suit with a burgundy tie. He had been scheduled to preside over a probate hearing at 9 a.m. Agent Kohler identified herself and presented the federal arrest warrant. Sloan, according to the arrest report and the body cam footage from the 2 accompanying deputy U.S. Marshals, did not immediately respond. He looked at the warrant. He looked at Kohler. He looked at the second marshal, who had positioned himself between Sloan and the open driver's side door of the Lexus. The exchange, transcribed from the body cam recording, was brief. "Judge Sloan, we have a federal arrest warrant. I need you to place your hands on top of the vehicle, please. There has been a mistake. On top of the vehicle, sir. I have a hearing at 9. I need to make a phone call. On the vehicle, Your Honor. Now. This is an appointment matter. Whatever you think you have, it is a mischaracterization of ordinary judicial discretion. Sir, we have the recording from the 8th of March. We have the currency from the 4th of April. Place your hands on the vehicle." At the mention of the 8th of March, Sloan's expression changed. The federal report describes it as, quote, "a discrete shift in posture and facial affect consistent with recognition." He placed his hands on the roof of the Lexus. He did not speak again until he was seated in the back of the transport vehicle, at which point he asked to call his attorney. The request was honored. He did not answer any further questions. Marguerite Sloan, who had come out of the front door of the house partway through the arrest, watched the transport vehicle leave the driveway from the front porch. She was still holding a coffee mug. The body cam footage from the trailing marshal caught her expression as the vehicle pulled onto Elm Vista Drive. She did not follow it. The federal indictment was returned by a grand jury in the Western District of Oklahoma on the 15th of April, 2025. It charged Gareth Prescott Sloan with 11 counts. Honest services wire fraud under Title 18 of the United States Code, Sections 1343 and 1346. Federal program bribery under Section 201. Conspiracy under Section 371. The Oklahoma Attorney General's Office concurrently referred state charges for judicial bribery under Title 21 of the Oklahoma Statutes, Section 380, and misconduct in office. The four paying attorneys were charged separately. Two of them, Roush and Whibley, entered plea agreements within 60 days of the initial charges and agreed to cooperate. Trant and Pomerantz elected to go to trial. Sloan retained Randall Presswood, a criminal defense attorney based in Oklahoma City with 3 decades of federal trial experience. Presswood filed the standard suite of pretrial motions. A motion to suppress the fishing lodge recording, arguing improper Title III procedures. Denied by the district court on the 12th of June, 2025. A motion to suppress the fruits of the Chambers search, arguing insufficient probable cause. Denied on the 3rd of July. A motion in limine to exclude the statistical analysis of appointment patterns, arguing that judicial discretion was not amenable to statistical review. Partially denied on the 9th of August, with the court ruling that the analysis was admissible as to pattern, though the defense could challenge its interpretive weight before the jury. As of the date of this reporting, the case is pending trial. The federal trial has been set for the 10th of March, 2026, in the United States District Court for the Western District of Oklahoma, before United States District Judge Harlan Petrovich, who was assigned after every judge in the Penwick County trial bench recused. Sloan is currently released on a $200,000 unsecured bond, with conditions that include the surrender of his passport and his firearms, and a prohibition on any contact with the 4 co-defendant attorneys, or with Miles Enderby. The Oklahoma Judicial Council suspended Sloan from the bench with pay on the 10th of April, 2025. On the 22nd of April, following the initial detention hearing, the suspension was converted to unpaid status. On the 9th of May, Sloan submitted a letter of resignation from the bench, effective immediately. His judicial pension, which had vested after 10 years of service, remains subject to a state administrative proceeding that will determine whether it can be forfeited under Oklahoma's Public Employee Pension Forfeiture Statute. The protected persons whose estates funded the arrangement have, in the months since the indictment, become the subject of a state court civil action filed by the Oklahoma Attorney General's Office seeking restitution from Sloan and the 4 attorneys. The estates in question, in the cases where the protected person is still living, include 47 individuals currently residing in nursing homes, assisted living facilities, and long-term care hospitals across Penwick County and 3 adjoining counties. In the cases where the protected person has died, the restitution claims will run against the residual estates or, where the residual has been distributed, against the heirs who received it. Mercy Halton is now 81 and lives in a memory care unit in Marlin Springs. She does not know the case exists. Elston Redgrave died on the 3rd of January, 2024, at the age of 93, without ever regaining the capacity to understand what had been happening to his estate. His granddaughter, who lives in Amarillo and had visited him twice a year, learned of the case from a local news report and drove 9 hours to Marlin Springs to speak with the Attorney General's investigators. She told them her grandfather had raised her mother alone after her grandmother died, that he had paid for her mother's nursing school, and that he had believed, until the last coherent day of his life, that the money he had saved would go to his descendants and to the small Methodist church he had attended for 61 years. Miles Enderby, the guardian ad litem whose memorandum initiated the investigation, is expected to testify at trial. His appointment volume in Penwick County, in the month since Sloan's suspension, has begun to recover under the interim judge assigned to the docket. And Gareth Sloan, 62 years old, former honorable judge of the Penwick County District Court, currently sits at the dining room table on Elm Vista Drive with a legal pad and a stack of discovery materials, preparing for the trial that will decide whether the last 14 years of his career end in the federal correctional system. This case was staggering, but the case on the right-hand side, where a public servant used a position of trust to prey on people who had no way to see it coming, hits even harder. Click it now.